Nice job, guys.
Can you hear me?
Yes, ma'am, we can hear you.
Okay. So this is if I remember. Just a minute.
Yes, ma'am.
Yes, please start.
The first matter is Satyam Singh versus State of NCT of Delhi.
Yes. Please start.
My Lordship, I am the Defense Counsel in the matter of Satyam Singh versus State of NCLT. I filed the bail application under Section 439 of the Code of Prison Code on behalf of the applicant accused seeking regular bail. Am I audible, My Lordship?
Yeah, you have filed the case on behalf of?
Ma'am, I filed the bail application under Section 439 seeking regular bail.
Okay. Okay. Please speak a bit louder, okay?
Yes, My Lordship. That applicant was arrested on 10th September 2019 and were wrongly and manifestly implicated in the FIR number 72/2019 registered at PS Lodi Colony, South Delhi under Section 321, 354B, 375 of the IPC. Copy of the FIR is annexed Annexure A.
Yes. Yes, proceed.
I request the OC to please refer to the page number 12 of the PDF file to show the annexure to the My Lordship. So, Your Honor, this is the case which is the for defense evidence is pending in front of the Gandhinagar court under the session judge. And
Can you please show the page number 12 of Annexure K, Shikhar? Am I audible?
Yes, ma'am, you are audible. I have allowed Swapnil to screen share so he can show.
Please tell the page number, Swapnil.
Yes, now proceed.
पिछली बार की तरह गड़बड़ी में हो जाता है
which
ठीक है
applicant is arrested.
अगर हो गया ना तो फिर वो पुराने वो
Swapnil, please share page number 12. Kindly mute yourself. Proceed.
Ma'am, this is the pending case under the stage of defense evidence in the Gandhinagar District Court. So my plea is this ki the charge sheet is completed and all the evidences are gathered. So what is the point of keeping my applicant behind the bars now under this pandemic?
Okay.
So ma'am, please grant a regular bail to my client.
Please speak on the merit. Please speak on the merit of the case. So only asking for bail, how can I give you bail? Where is the merit of the case? Focus on the merit. Can you hear me?
Yes, my lordship, you are here.
I'm asking you, please speak on the case.
Because the accused has been falsely implicated in the present case, as the allegations level against accused in the FIR are not only ill-founded but also improbable and cannot bring home the charges mentioned in the FIR.
भैया आपका शायद नेटवर्क इशू आ रहा है तो रीजॉइन करो फिर से.
3 बार रिजॉइन करते हैं होस्ट कनेक्ट हो ही आ रहा है
क्योंकि मेरे यहाँ से बाकी सब ऐड हो रहे हैं, आप यहाँ से ऐड नहीं हो रहे हो ना, शिखर के से ऐड हो रहे हो.
तो मैं लीव करूं मीटिंग?
कर रहा हूं बट मेरे में पोर्ट है भाई.
ठीक है, आप रीजॉइन करो, मैं देखती हूँ इसमें.
प्रतीक्षा पहले तो म्यूट करो खुद को. गाइस अभी थोड़ा प्रॉब्लम हो रहा है, नेटवर्क प्रॉब्लम है. तो अभी मोनिका मैम का भी हो रहा है, तो ममता मैम का. तो प्रतीक्षा एक बार मैम से कांटेक्ट करना प्लीज.
वो तो मैं कर रही हूँ बट वो भैया का भी.
Can you hear me?
Yes ma'am.
Ma'am, your voice is little breaking.
Can you hear me?
Yes ma'am, we can hear you,
Yes,
but your voice is not clear.
My boss is, what will I do? Because of the network problem might be.
Okay ma'am. So
हेलो म्यूट है मेरा.
हेलो। हाँ
प्रतीक्षा ऐड करो ना यार, इतने टाइम से वेट आ रहा है।
तुम लोगों का पता है शायद नेटवर्क इशू आ रहा है, वापस से रिजॉइन करो बिकॉज बाकी सब लोग ऑलरेडी ऐड हो चुके हैं।
Can you hear me?
ठीक है, अच्छा एक मिनट।
Can you hear me, students?
Yes, ma'am. Yes, ma'am. We can hear you.
Is my voice breaking or fully audible?
No, ma'am. No, ma'am. It's all right right now.
Audible, ma'am.
Okay, start. Without wasting much time, please start.
Yes, ma'am. Just Swapnil is here and Monica is coming. Actually, her net is also disabled, I guess.
Okay.
Monica, Swapnil, ma'am is here. You guys can continue.
Monica, please start. Can you hear me?
Yes, ma'am. Your ladyship, I request you to kindly do not grant the bail because it's the rape case, not just a theft case or something else. It is true that till now the case is not proved, but still the charges are on Satyam Singh. So there is a chance or there is a possibility that he can harass my client after getting out on bail. So I just request you to kindly do not grant the bail. And there are no errors or something else in the charge sheet which can prove that Satyam has not done that.
My lordship, I'd like to interrupt between this because
Yes.
the FIR was filed on 10th September 2019 and he was in the custody from that date only. And
Okay.
with him, his servant also was in the custody and got arrested. But later on, he got discharged by the Shri Rachit Patra ASJ se, and prosecution evidences are also done. And so there is no point to harass or threaten the victim because prosecution has already show their witnesses and evidences at now. So this is the stage of defense evidences which is pending in front of the Gandhinagar District Court. So ma'am, what is the purpose of keeping behind my client right now?
So the prosecution
Your-
witness has been PW has been over. So
Yes,
only
ma'am.
the DW is now left.
Yes, ma'am. Prosecution evidence stage is over. The victim is already given her statement. So what is the point of now keeping my applicant behind the bars now?
So how many days your client is there inside the jail, JC? Kitna din hua?
From the date 10 September 2019.
10th September 2019
Yes, ma'am.
till
And-
date.
Yes, ma'am. Till date, he is in the judicial custody right now. Ma'am, he is
Okay.
the regular student of the university.
So he was in, just a minute, he was in PC for how many days?
Ma'am, ma'am, he haven't been in the PC. He directly go through the JC.
So he wasn't arrested by the police. He wasn't in PC. He was directly in jail. I mean, he was directly put in JC.
Yes, ma'am.
What the prosecution lawyer is saying?
Yes, your ladyship, the accused was in the JC from the very beginning and he hasn't gone to
How
the
it can be?
JC.
So he was put from the very first day in JC. He was not in PC.
No, ma'am. He was in, from the very beginning, he is in JC.
Okay. Okay. Anything else?
Ma'am, he is the regular student of the university. I also attest his ID card, identity card of his house and or his university. Ma'am, his degree is going to hamper without lack of
What
attendance.
about the medical evidence? What about the medical evidence?
And ma'am, if you see the charge sheet, there is no
What about the
any.
medical evidence? What about the medical evidence?
My lordship, I'm
Is he
sorry.
been implicated? Is he been implicated in the medical evidence? Yes or no?
Yes, ma'am. He has gone through the medical evidences as well.
So what is the report? What is the report? What is the statement in the report? Can you please refer to? I would ask the prosecution lawyer to interfere. What is the statement in the medical report?
Your ladyship, in the medical report, there's written by the doctor that the semen is detected of accused only,
So anything else?
and the statement of the doctor has already been taken.
Ma'am, if you see the medical report of the victim, you can see there is no other bruises on her body. Yes, there is a possibility of the semen of the victim, of the accused, but it can be
So you are saying
consensual.
there's a possibility. There's a
Your
possibility, right?
ladyship, the defense is saying on his own that there is a possibility, and my client is also a regular student of that university as well.
My lordship,
Did he take the responsibility that his client will not do or not harass my client in the university or anywhere else if the prosecution evidence has been done?
ma'am,
Okay. Anything else?
my lordship, my plea is ki that can be consensual. That haven't proved that ki that is not consensual. And
Yes, your ladyship, it has not been proved that it was consensual or not consensual. It was rape or not rape.
And
So
yes, ma'am,
I request you to kindly do not grant the bail because it's not proven yet, and it's about the life of a girl. We don't know what will happen in the future to her.
Okay, I
If
got it.
and my
Okay.
lordship, yes, my
Yes.
accused is ready to give every type of undertaking in his bail application that not to hamper and do nothing to do with the victim.
Okay. I'm reserving the judgment. So the order. So I'll give you the order like in 1 day or 2 days. I'm reserving the order for the time being. Thank you.
My lordship, I will like to refer some cases as well if you like to see.
So you just give to the OC. They are going to mail me out. Okay.
I already mentioned in my bail application if you refer, my lordship.
So you have already mentioned, right?
Yes, ma'am.
What is the name of the what is the name of the case?
Karan Oberoi versus State of Maharashtra. Ma'am, Karan Oberoi versus State of Maharashtra.
Okay.
That
Yes.
was the case under rape 376, and the Karan Oberoi is granted bail from the High Court of the Maharashtra.
Okay, counsel.
And
I got it. I'm reserving the order. I'll get back to you. Okay.
And another case is Shubham versus State of UP.
Okay. I got it. I'm reserving my order. I'll give my order, and then you will just see through the order.
So my lordship, my only plea is that please keep this in mind. My client is suffering very hard because this kind of pandemic is also there in the world. There are chances that he might got affected through this COVID-19 also, because I have heard from the applicant that there are some other people who are affected in that area.
Okay.
So please,
Your
my
lordship,
lordship,
my client has already been gone through so much, and if he gets out on the bail, it's 100% sure that she will suffer more.
Okay, you can end your argument here. I'm reserving the order.
Ma'am, if you see the order of charge, so prosecution also framed the servant Golu under these charges, but
Swapnil, I have already reserved my order. I'll give my order, and then if you have any grievances, you can go for another application. Thank you.
Thank you, my lord.
Your Ladyship.
So this is the next case, right?
Yes, ma'am. Advocate Nutan Shakya and 𝐒𝐿TAC. You both can unmute yourself and can continue. Nutan Shakya and
Good
𝐒𝐿TAC.
evening. Your Honor, this present application is filed under section 439 of CRPC for granting bail in FIR number 043 under section 302(120)B of IPC and under section 3, section 27, section 25 of Arms Act.
Yes, please proceed.
Am I audible?
Yes, yes.
Your Honor, the quashing petition was filed before the before Honorable High Court. There, Justice Rupesh sir granted bail, but with condition that if Session Court will allow.
Okay, proceed.
Your Honor, in the present case, the FIR was lodged on 11th of September 2019. And after conducting the investigation, the charge sheet was submitted on 13th of September 2019. Your Honor, there are many.
Wait, counsel. FIR was actually filed on 11th September 2019.
Yes, Your Honor.
Yeah, and then charge sheet
Was submitted on 13th of September 2019.
13th of within 2 days. Wow.
Yes, Your
Okay.
Honor, but if you may refer to the arrest memo and other documents which are annexed with the charge sheet, they are prepared after 13th of September 2019.
Your Ladyship, I would like to interrupt between this.
No, wait. I'll just give you another chance. I just want to hear from the other counsel. So 11th September 2019, FIR was filed. CS was filed on 13th September 2019. Okay, then.
Yes, Your Honor. Your Honor, the other documents are prepared after 13th, and also, Your Honor, there are major documents which should be attached with the charge sheet but are not there in the charge sheet. There are many procedural loopholes, like PCR report is not there, medical examination of accused was not conducted, and hence there is not any document for the same.
Okay.
Your Honor, the inquest report was also not made. As per the fact of the case, the inquest report should be made, and hence therefore not any document for the same.
Counsel, 1 minute. CS was filed on 13th September 2019.
Yes, Your Honor.
What do you mean by the other documents? You're
Yes,
talking
Your
about.
Honor.
What do you mean by the other document? That means the PCR report, medical examination, and the inquest report was not filed, right?
No, Your Honor. No, Your Honor. I mean that the arrest memo was made on 16th.
Arrest memo was made on 16th. Okay.
Which is, yes, Your Honor. The charge sheet which is already naming the accused on 13th, then how can it be possible that they are arresting them on 16th but naming them before on 13th only?
Okay. And your allegation is also the PCR report was not filed. Medical examination was not done. Medical examination was not done. And you're not audible.
The PCR report is not there. The medical examination was not done of the accused, and also the inquest report is not there.
Okay, 174 and 175. Okay, then.
Your Honor, also the post-mortem was conducted without inquest report and any written order from the side of police or any magistrate. But without the permission of the same, the post-mortem can't be done. Moreover, Your Honor, there is not any evidence against my client which shows that the offense was committed by him only.
Okay. Do you have anything more
Your
to
Honor,
say?
my client, yes, Your Honor, my client is in jail since more than 7 to 8 months. So I request this honorable court to grant the bail as he is the sole earner of the family. And during this pandemic situation, his family needs the client.
Okay. Anything else?
Yes, Your Ladyship.
Yes.
Yes, Your Ladyship, the defense counsel is mentioning wrong in the prosecution evidence stage. It was same was deposed by the IU that it was a clerical error on the charge sheet, which is dated
DP, I
1309.
cannot hear you. I cannot hear you. I cannot hear you.
Your
Please.
Ladyship,
Yes.
that was a clerical error on the charge sheet, which is dated 1309/2019. And the arrest memo was made on the 16th of September. And the defense counsel, which is saying that the family of accused is dependent on him. The accused is unemployed, which is given in the arrest memo.
No. What you are saying, basically, the CS was actually filed on 13 September 2019, and the arrest memo was
Made
filed on 16 September. Yes. So
Your
where is
Ladyship,
the
charge sheet
clerical
was
error?
not filed on 13 September. It is a clerical error.
So when it was filed?
It is filed afterwards. After
So have
16.
you given any put up any petition or application in respect of the clerical order?
No, Ladyship.
So how can you say that's a clerical order? How can I entertain that? Okay, proceed.
Your Ladyship, and the grounds on the which the defense is lying is also not mentioned in the bail application. It is different, and the which is saying that second ground, the application is innocent, which is the matter of trial, and the third ground, which is saying that there are irregularities on the arrest memo, which is not, the defense is not mentioning clearly that what are the irregularities on the arrest memo.
So you just tell me one thing, Counsel. PCA report has been filed, yes or no?
Your Ladyship, the Justice Rupesh Singh has given the order that the PCR should be submitted within 2 days. I have submitted that the before defense evidence stage, the PCR will be reached to the defense counsel as earlier.
It has not been filed by you within 2 days, yes or no?
No, ma'am. Today the order has been given by Justice Rupesh.
Okay, today. So within 2 days you have to file it. Okay,
Yes,
and medical examination? Why not medical examination was held?
Your Ladyship, the same has been filed by the sketch and the written orders, which is not received to the postmortem, which were told to the postmortem that which was told to the Shubham Mishra, the forensic expert who has done the postmortem, will be submitted in the 2 days to the defense counsel.
So everything will be filed after 2 days.
Because
So
in
what
prosecution evidence,
has prevented you from filing PCR report, which should have been filed beforehand in the initial stage, even the medical examination in the initial stage? What has prevented you from filing?
Yes, Your Ladyship, it was the error on the part of the IO. It was decided in the it was said in the prosecution evidence.
What the IO was doing? IO was sleeping? What the IO was doing?
Yes, Your Ladyship, the IO has made a mistake by not attaching a
So
PCR
mistake.
record.
Okay, being an IO, he's making a mistake. Very good. And what about the inquest report?
Your Ladyship, no inquest report has been made.
So that is not mandatory, right? Or that will be filed after 2 days?
Yes, Your Lady, if it
Now
is,
inquest report can be filed now.
Okay, so you are saying again the inquest report also will be filed after 2 days. Can it be done so?
No, Your Ladyship.
Okay. Okay, anything else?
No, Your Ladyship.
Okay. Other counsel, do you have anything to say?
Yes, Your Honor. I'm just mentioning that that after all these loopholes, procedural major mistakes, and there as there is not any evidence also against my client, so I just humbly prayed before this honorable court to grant the bail for the same.
Okay. Thank you.
Your Ladyship, I want to.
I'm reserving the order again, and I'll get
Your
back
Ladyship,
to you.
I want to say one thing.
Yes.
There
Please
are the
proceed.
3 eyewitnesses, Your Ladyship.
Yes.
Which are the prima facie that the accused has committed the crime.
No, eyewitnesses I can understand. I can. There is no doubt you can give eyewitness. You can give hearsay evidence. That's up to you how you're going to prove the case. How you're going to corroborate the evidence. But my question is that what has prevented you from filing PCR report? Okay, you're going to file within 2 days. You can do so. But what about the medical examination and the inquest report? This is a case of 302, read 120B, read with 320 IPC, along with the Arms Act. So if you want the accused to be in jail, you have to be well equipped with all these documents, right? So there is obviously a lacuna on your part. So you are saying you're going to file the PCR report within 2 days, right?
Yes, ma'am, as per
Am
the
I
order
right?
given by the Justice Ruperson. Yes,
Okay.
yes, Your Ladyship.
A medical examinations, obviously, okay, inquest report also cannot be done. Okay, that's all. I'm reserving my order.
Okay.
Okay, Your Honor.
Yes, what is the next case?
Your Honor, this case is in the matter of 𝐒𝐔𝐿𝐿 versus State of NCT of Delhi.
Yes.
Your Honor, on 9th of September 2019, an FIR was registered.
Just a minute. This is about the charge sheet, right?
No, Your Honor. Your Honor, it is about 216, the alteration of charges.
Yes, it is about the alteration of charge sheet, 216.
Yes.
Okay.
Yes, Your Honor.
So the charge sheet was filed when?
The charge sheet was filed on 17th of October 2019, Your Honor.
17th October 2019. Okay.
And
So who has
subsequently
conducted the charge sheet? Who has conducted the charge sheet?
Yes, ma'am. Yes, ma'am. Hello.
Yeah,
Am I
am I
audible, ma'am?
audible?
Yes, ma'am. Yes, ma'am. I can hear you.
Yes, charge sheet was filed on 17th October 2019. Are you PP?
Yes, ma'am. I'm the PP in the case.
Okay.
Yes, ma'am.
17th October 2019. So
Yes,
these, can you tell me the charges? That is 302.
120B,
34, 120B, and 27 of the Arms Act, Your Honor.
So it is not written here in the screen. Where is 120B?
It was it was not in the FIR, but at the framing of charges stage, it was later added by the learned session judge.
Okay, tell me that only. Okay, 302, 34, 120B, and 27 of Arms Act.
Yes, ma'am.
Yes,
Okay.
Your Honor.
Okay, now proceed.
Your Honor, in the
Yes,
instant matter, Your Honor, in the instant matter, till now, since the prosecution stage has ended, prosecution evidence stage has ended, Your Honor, and till now the court has not received the pistol or the photograph of the pistol. Also, Your Honor, if I may ask the members of the registry to kindly share screen for the prosecution evidence stage order. Your Honor, there was prosecution witness 5, Mr. Anand Singh, who was one of the person who was there at the time when the pistol was seized. And he said that he was not present. Rather, the sign was taken 10 to 15 days after the seizure was done.
So
Also, Your
you
Honor,
just tell me, counsel, just one thing. I'm interrupting. You just tell me.
Yes, Your Honor. Yes, Your Honor.
What charges you want to alter? What are the charges?
Only to remove 27, ma'am. 27 of the Arms Act.
Only you want to remove 27 of the Arms Act. Okay.
Yes,
so why
yes,
do
Your
you want? Why do you want to remove 27 of the Arms Act? What is your defense? What is your argument?
Your Honor, because till now the court has not seen the pistol, even after the completion of the prosecution evidence stage.
It has not been
Also,
seized. It has not been seized.
it has been seized, ma'am. However, it has not been produced in front of this court, even after completion of the prosecution evidence stage. And neither the charge sheet.
So I am interrupting PP. What do you want to say on this?
Ma'am, I just want to say, like apart from this LTAC, ma'am, I'm not a person competent to hold the possession of a pistol, ma'am. The required thing that the seizure memo, I have already submitted it in the charge sheet, ma'am. The seizure memo is already there,
I
and
I understood one thing, that it has been seized. By what?
Yes,
But
ma'am.
why it has not been produced?
Ma'am, the thing is, ma'am, how am I supposed to bring a pistol in the court, ma'am? No, I'm not a competent person. Apart from these proceedings and all, I'm not a competent person to hold a possession of a pistol, ma'am.
So who is the right person to do it? Can you tell me?
No, ma'am. Like apart from this proceedings of this competition, I'm talking about apart from these things, ma'am. How, like, I just want to ask even the OC and even the learned ma'am, how am I supposed to arrange a pistol in the for to show in this case, ma'am?
Okay, stop here. The other counsel.
Your Honor, there was already a notification by the registry that we can attach not the pistol. Definitely, we don't have to attach the pistol.
Yes.
We can attach a photograph of the pistol,
Yes.
or any other photograph, and that can be taken as a murder weapon. But in this case, till now,
yes,
in this case, till now, the court has not seen the pistol, Your Honor. The prosecution evidence stage has been laid down till now. Also, in the prosecution evidence stage, Your Honor, prosecution witness 5 has said that at the time of seizure of the pistol, prosecution witness 5 is a SI, Your Honor, and he has said that he has signed on the seizure memo after 10 to 15 days of when the seizure was done. And also, Your Honor, Mr. Ajay, prosecution witness 4 has said that there was not one, but rather than 3 pistols, Your Honor. This is a very conflicting theory, and since the court has not seen the pistol till now, therefore we plead that if there is not at all possession of arms in this case, how can Arms Act at all come into picture?
So, counsel, prosecution witness has testified that there were 4 pistols, right?
Sorry,
But
3 pistols, Your Honor.
4 pistols, 3.
Yes,
3
Your
or
Honor.
4?
3 pistols. 3.
Pistol, okay. So out of 3, 1 pistol was actually seized.
Yes, that is their theory, Your Honor.
That is their theory, or it's a seizure report is reflecting the
It is-
fact?
The seizure report is reflecting about 1 only.
1 only. So, okay, then?
Should I continue, ma'am?
Yes, proceed.
Yes, my lords, ma'am, I want to say that filming or like clicking the pictures of any kind of weapon or something, it is actually the violation of Arms Act in India. So that is why that is the only reason I didn't.
Can you tell me the provision that it is a violation of Arms Act? Can you tell me the provision?
Ma'am, I'm really sorry.
You cannot say something in the air, right? The code.
Yes, ma'am. Yes, ma'am. You're right, ma'am. And I'm clear, like I'm being very honest. I don't know the exact provision for the same, but yes, it is a violation of.
This is the work of the PP. This is the work of the PP to assist the court, right?
Yes, ma'am. It is.
So where is the assistance that I'm getting from PP? Okay, proceed.
All right, ma'am. And secondly, ma'am, the thing that they are saying that there is the physical witness Ajay, son of 𝐒𝐔𝐁𝐄, said that there were 3 pistols, and in seizure memo there is 1 pistol. I really think, ma'am, this is the part of trial. Obviously, if it is like that, it will favor them in the acquittal of their clients. Right?
PP, I just want to hear you one thing. You just tell me one thing.
Yes,
why Section 27 of Arms Act should be implicated against them?
Because, ma'am, there has been a murder, and the murder has been done by a pistol only, and the eyewitnesses has confirmed it, and even the police has confirmed it. The whole charge sheet is confirming that the murder was done by the pistol. So obviously there is a need of applying 27 Arms Act.
If a murder is done by a knife,
yes, ma'am,
or if a murder is done by any other arms,
yes,
so will the Arms Act will be attracted?
Ma'am, for the knife, yeah, ma'am, I think so. It will be applied, ma'am.
I think so.
Ma'am, I'm not sure. Being completely honest, I'm not sure, ma'am.
Okay.
Your Honor,
for knife, I'm not
27,
sure.
Your Honor, Section 27 lays down the provision of punishment if there is an offense committed under Section 5 of the Arms Act.
Yes,
And
what
Section
Section 5 is saying? Yes.
Section
What
5
is
talks
saying?
about Section 5 talks about sale. Section 5 talks about production. Section 5 does not talk about murdering.
But Section 5 talks about possession.
Yes,
if I may read Section 5, Your Honor. If I may read Section 5, Your Honor. License for manufacture, sale, etc. of arms and ammunitions. No person shall use, manufacture, sell, transfer, convert, repair, test or prove, or expose or offer for sale or transfer, or have in his possession for sale, transfer, conversion, repair, test or prove any firearm or any other arm of such class or description as may be prescribed, or any ammunition, unless he holds in this behalf a license issued in accordance with the provision of this act and the rules made thereunder.
Okay.
And that is possession for sale, ma'am, not possession for murder. For possession for murder, already 302 takes care of murder, ma'am. There is no need of implicating Section 27 in the instant case.
Yes. Anything else? Anything else?
Ma'am, should I?
Yeah.
Well, obviously, ma'am, for a murder, ma'am, for a murder, like my learned friend is actually now also commenting onto the capabilities of learned session judge, ma'am, because obviously the learned session judge better knows what sections are to be applied or not. Ma'am, if these charges were applied, obviously they were applied as per the laws only, ma'am.
Yes.
And 27 Arms Act, ma'am.
You know, that is why we are again. That is why we are again in front
Argue
of
on
you,
the merit.
Your Honor.
Please argue on the merit.
And,
argue on the merit.
And moreover, Your Honor, any such alteration of charges will not at all affect the trial. So there is no need to worry about it. I would cite the case law of 𝐒𝐄𝐈𝐁𝐄 versus State of Maharashtra, where the court itself has held that Section 216 of CRPC gives power to the court to add or alter charge at any time before the judgment is pronounced. And obviously, once the charge is framed, it cannot be said that the same cannot be subjected to any kind of further alteration.
Yes.
Ma'am, I would also
Anything else?
Yes, ma'am. I would also like to rely upon. Just a second, ma'am. Yes, ma'am. In this Dr. Nallappa Reddy, Sridhar Reddy versus the state of Andhra Pradesh and another, ma'am, the Supreme Court held that if there is a presumption, even if there is a presumption of any crime or any offense, even if there is a presumption, then the charges are to be applied, ma'am, are to be framed, and that is a part of trial, whether the accused is proven guilty or non-guilty. These are the parts of trial, ma'am. But if there is a presumption, the charges are to be framed, ma'am. And there are presumption. There is a seizure memo, ma'am, and their murder has been committed by the pistol only, ma'am. So there are presumption.
Can you tell me the name of the case? Can you tell me the name of the case?
Yes, ma'am. Dr. Nallappa Reddy, Sridhar Reddy versus the state of Andhra Pradesh and another.
Sridhar Reddy.
Your Honor, if I may.
Yes, I'll give you. Nallappa Reddy versus Sridhar Reddy.
Versus state of Andhra Pradesh and another. It is, ma'am, criminal appeal number 1934 of 2019 arising out of SLP criminal number 3884 of 2019.
Yes.
Yes, ma'am.
Your Honor, as the counsel is relying on the.
You just tell me one thing. How
yes,
this particular section of 27 of Arms Act is prejudicing your client?
Your Honor, what we believe is that this addition of charge under Arms Act is just frivolous in nature. It doesn't have to do anything with the merits of the case. Even relying that there is a presumption of commission of the offense, in that case, a charge can be framed, Your Honor. However, in the instant matter, none of the evidences prove that my client was involved in sale, purchase, manufacturing of the arms. But and hence Section 27 cannot come into picture. So it is very far-sightedness, ma'am, to say that they were also involved in sale. And even if they were involved in sale, there is no evidence on record in the charge sheet to prove the same. Hence, the section is not at all required.
Okay.
Moreover, it bears a punishment of around 7 years, ma'am.
Okay. Anything else?
Ma'am, like as my learned friend said that 27 is not applicable here, ma'am. I would like to give a light upon that the section 5, according to which section 25 is said. Section 5 says, ma'am.
You just tell me that this particular accused person.
Yes, ma'am.
How can you prove that he was engaged in the the sell and the selling of arms and all? How can
he was not. Ma'am, he was. I'm not proving anything about sale or something. I'm just saying that he was having the possession of the pistol. That is what I am saying, and that is enough to prove 27 Arms Act. The possession. He was not licensed to keep a pistol, and even he fired and killed a person.
So can you tell me what section 27 of Arms Act specify?
All right, ma'am. Just a second, ma'am.
Is it only the possession or something else? It reflects.
All right, ma'am. I'll read it for you, ma'am. Just a second, ma'am. It is section 27
I know,
says.
you just read it for yourself. I know. I just want you to read it for yourself. Yes.
Okay, ma'am.
Read
It says for the punishment of using arms, ma'am. Whoever uses any arms or ammunition in contravention of section 5 shall be punishable with imprisonment for a term.
Section 5.
Section 5. So I just want to tell you that what section 5 tells, because section 27 cannot be read disjunctively, right? I mean, yes, it cannot be read in isolation because two section 27 and section 5 goes together. So I just want to tell you, I will keep the charge of section 27 PP. There's no problem. But my question is, you just answer my question. If section 27 has to be there, then section 5 has to be complied.
Yes, ma'am.
So what section 5 talks about? Section 5 talks about not about the individual possession, but for the purpose of selling.
Not just for selling, ma'am, for transfer, for conversion, for repair.
For transfer. So can a single pistol can be used to attract section 5 of Arms Act?
Yes, ma'am. Yes, ma'am, for sure, ma'am. There were 3 accused in this case, ma'am. It may be transferred from one person to.
So there were 3 accused. But out of 3 accused, yes. So out of this particular 3 accused, so all the 3 accused used one pistol, or only one pistol was seized?
Ma'am, only one pistol was seized. That is the thing. Only one pistol was seized.
What about the 2 pistols? What about the 2 pistols? Why couldn't you seize? Why couldn't the IO seize it?
Ma'am, that is the thing that IO can better explain it in the session code, ma'am.
Why not PP?
Because ma'am, IO is the authority to seize the pistols, ma'am.
No, IO is the authority, but during the framing of the charge, it is the priority. I mean, the PP has to do the full thing.
Yes, ma'am, you are right. But ma'am, secondly, like even having a possession of unlicensed arms and ammunition is an offense under section 5.
I understood. Possessing anything about the he can be implicated for another section of Arms Act. There is no problem. But the thing is that when you're trying to implicate a person with a particular section, and that section is cannot be read in isolation. It has to be read in accordance with section 5 of Arms Act. But what section 5 is saying is for the purpose of transfer of possession. Right?
Ma'am, there is also a term test or proof in section 5, ma'am. Test or proof, they even have some wide scope, ma'am. Even testing means firing. A testing of a weapon also says some firing only, ma'am. If you're getting me, ma'am.
Your Honor, but if
you're going something otherwise,
and
you're not audible.
For the purpose of interpretation of, Your Honor, for the purpose of interpretation of this particular section, we should first focus on the marginal note of the section. The marginal note of the section itself says that it is for the purpose of sale, transfer, manufacturing. And what my learned friend is talking about, that possession should be in consonance with all these things. That possession should be either for sale. That PP, possession should be.
So PP, if you really want, I can do one thing.
Yes, ma'am.
That after you are as the counsel is asking for the alteration of charges.
Yes, ma'am.
PP, can you hear me?
Yes, ma'am, I can hear you. Yes, ma'am, I can hear you.
Yeah. So if you want this particular section to be implicated against the accused, if you want some dates, you can take to prove. But if it gets altered I mean,
Yes, ma'am.
before the judgment, another alteration cannot be done, right? So it's
Yes,
better
ma'am.
if you want to take, yes.
However, Your Honor, this will not at all culminate the proceedings. Like even if you alter the charge, that will not culminate the proceedings. And moreover,
No,
there is no.
I'm asking PP what PP is saying about this.
Ma'am, I
Because
am
during
just
the
saying that
charge, yes.
ma'am, framing of charges was done late in November, ma'am. After 4 or 5 months, my learned friend is
So
realizing
it
this
can be
thing,
done
ma'am.
before. It can be done
Yes,
at
ma'am,
any
it can be
stage.
done, but yes, ma'am, it can be done at any state. But my point here is, my learned friend is just trying to delay the proceedings. It is just trying to
No,
delay the process.
it
Sorry,
has
ma'am.
nothing to do with the. It has nothing to do with
Ma'am,
the merit of the
ma'am,
case. Try to
ma'am,
understand.
yes, ma'am, I'm getting, ma'am. My learned friend has also moved questioning of the charge sheet twice in the High Court, ma'am. It has
He
got
can.
rejected.
It is his right. He can do so. There is no
No, ma'am.
problem. But
What I am trying to prove here is that he's just trying to. My learned friend is just trying to delay the
try
proceedings
to
of
do
this
the
case.
dilatory practice.
Sorry, ma'am.
Dilatory practice.
Yes, ma'am. He's just trying to misuse the power, misuse the process of law, ma'am. It's nothing else than, ma'am. Because, ma'am, Section 5
So can you give
has.
me what power under which section he is misusing the power?
Sorry, ma'am.
You are saying he's
ma'am.
misusing the process or the abuse of the court. Which section it
Yes.
it attracts?
Like, ma'am, he's which section? Like he's just misusing the powers under provided under 482 or provided under 216, ma'am. That is what I'm trying to say.
482, what speaks about the inherent power.
Yes, ma'am. I'm saying that my learned friend is just misusing the power, inherent power, the process of law.
So how is he misusing? That only I'm asking you, PP. It is his right.
Yes, ma'am. It is his right. I understand that.
You can only,
Your Honor,
you
if I
can
may,
only...
if I may.
Yes.
Your Honor, coming to the point that why this petition after 5 months, Your Honor, once the charges were framed, we thought that they will be leading some or the other.
Do you think, my counsel, this point needs to be argued?
No, Your Honor, just a clarification that in
Do
the
you need to
we
clarify
thought
this point? Do you need to clarify this point?
not at all, Your Honor. Like if Your Honor is satisfied, then.
No, it's not. It's not about the satisfaction. It's about the the power and the authority of Section 216.
Yes, Your Honor. Like that the matter charge at any stage.
Yes, I got it.
I got it. Anything
else you want to say, PP?
Ma'am, the only thing I want to say is that Section 5 has really a wide scope. There is testing. There, like it really satisfies the provisions and facts of this case. And Section 5, along with Section 27, they both are maintainable here. And I don't I just request this court.
So you do. This is Section 5. Section 27 is maintainable. I'm going with my PP's point. But how are you going to protect Section 27 and Section 5?
Ma'am, I am.
Do you have any evidence in your hand? Show me. I just want to see that.
Ma'am, there are eyewitnesses who confirm that the deceased died by the gunshot of the accused, by the gunshot which the accused fired. There are FSL reports that the bullet which was found in the body of the deceased was fired from the gun that was seized.
That is being taken care by 302. That I'm not at all arguing. That I'm not at all rebutting that presumption that 302 will not try.
Yes, ma'am.
But my question.
Yes, ma'am, I got your question. And secondly, ma'am, the term that is here, expose or offer for sale or transfer or have in possession for sale, transfer, conversion, repair, test or proof. Ma'am, testing of the gun. It means the firing. It has a really wide scope. This term has a wide scope, ma'am.
Okay, do you have any case reference in respect of this? Testing means firing.
Ma'am, presently I don't have any case preference for where testing means firing, but
you all argue for the code without any cases, without any decisions.
But ma'am, secondly, the thing is,
you cannot say something in the air, PP, please. No.
Yes, ma'am, I understand. I understand, ma'am. But testing clearly shows that it is firing, ma'am. What does a gun testing means? I just want to.
I understood. Testing is firing. 1 plus 1 equals 2 because there is a calculation that 1 plus 1 means 2. Because it's being proved how 1 plus 1 equals to 2. Can you prove it? You can prove it. But how can you prove that testing is fine? Try to understand. You cannot say something in the air, right? Again, I'm saying.
Fine, ma'am. I understand your point, but I just rested
Like, for
only.
example, for constituting the offense of rape,
Yes, ma'am.
penetration, any kind of extent of penetration is sufficient to prove the offense of rape.
Yes,
Here, there
ma'am.
is a case.
Yes,
So
ma'am.
similar in the case when you're saying that firing means testing. I mean, testing is firing. So do you have any case in your hand? Or should I give you some case?
I don't have any case regarding this, ma'am, in my hand actually.
Okay. 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 So there is no other, anything else you want to say? Both of you?
No, Your Honor. No, Your
It's
Honor.
over.
Okay. Thank you. Proceed with the other case.
The next case is State versus 𝐅𝐨𝐥𝐥𝐨𝐰 and others.
Yes.
Ma'am, since I am the counsel in the same, can I get 2 minutes of the question?
Yeah. Sure.
Thank you.
OC, can you hear me? Pratiksha?
Yes, ma'am.
Yeah, I'm reserving the order of the 4 case, and I'll just write the order and then I'll forward the order to whom? To you.
Yes, ma'am.
Okay. So wait for 1 day.
Okay, ma'am. No problem.
Your Honor, this case is in the matter of State versus 𝐅𝐨𝐥𝐥𝐨𝐰. Your Honor, an FIR was filed on 10th of September 2019
Yes.
under section 302, 392, 394, 34 IPC.
Just a second. FIR was filed on which date?
On 10th of September 2019.
Okay.
And then the under section 302, no, this is some other case which they are projecting. Like the sections are not same. It was under 326A, 302.
You just tell me whether, tell me what are the cases, what are the charges?
Your Honor, at the current date, the charges are of section 302, 307, 326A,
Yes.
376,
Yes.
120B
Yes.
of IPC, and
Wait,
25 of
376? Wait, 376 then?
120B
Read with 120B, yes.
of IPC,
Yes.
and 25 of the Arms Act.
So which one do you want to alter? 25?
No, we want an addition of charge, ma'am, because at the time when the charges were framed, against accused 4 and 5, the Honorable Court has not framed the charge.
Here, you are the PP, right?
Yes, Your Honor.
You are the PP. So you want addition of charges. Okay, tell me what is
Your
the
Honor,
charge
on the day when the charges were framed,
Yes.
the Honorable Sessions Judge has not framed the charges against accused 4 and 5
Acha.
under section 302, 326A and 376.
326A and
376.
Acha. So 1, 2, 3 against accused number 1, 2, 3. So the charges
Your Honor.
against accused number 1, 2, 3 is 302, 307, 326A, 376, 120B and 25 Arms Act, right?
Yes, Your Honor.
And against accused number 4 and 5, it is under section 302, 326A, and only 376.
Yes, Your Honor.
Am I right?
Yes, Your Honor.
So against accused 4 and 5, which weren't there, 120B was not there.
No, only 120B was there, ma'am.
Acha, accused 4 and 5 ke against me only 120B was there.
Yes,
And?
ma'am. And I'll just get back to you with the order, ma'am. Once a second. Just a second, ma'am. I did not get the time. I'm searching for the order. Can the OC project the order, because I cannot do it from my phone?
Vaibhav, you just tell me one thing.
Yes, Your Honor.
Accused number 1, 2, and 3. What were
Yes,
the
Your
charges?
Honor.
What were the charges? 302,
376.
No, 302,
302 was there. Yes.
307 was there.
376.
326A,
Yes, Your Honor. 307.
120B,
Yes, Your
and
Honor.
25 of Arms Act. But
Yes, Your Honor. Yes, Your Honor.
Against accused 4 and 5, only
Yes, Your Honor.
120B was there and
Yes, Your
25
Honor.
Arms Act was there, right?
Yes, Your Honor.
Yeah. Now tell me, what are the addition of the charges against
Your
whom
Honor.
you want to implicate?
Your Honor, 302 should be added against 302, 120B,
Yes.
and 34 against 4 and 5, accused 4 and 5, Your Honor.
No. Again, I got confused. Accused number
Yes.
1 and 2, accused number 1, 2, and 3, 302,
Accused-
307. I'm
Yes, Your
repeating. 307, 326A, 376, 120B of IPC, and 25 Arms Act was implicated against accused number 1, 2, and 3. But
Yes, Your Honor.
against accused number 4 and 5, 25 of Arms Act and 120B.
Yes,
With
Your Honor.
what? With what? It cannot go independent.
120B was not there, ma'am. Only 25 of Arms Act was there.
Only 25 Arms Act was there. Okay.
Yes,
okay,
Your Honor.
okay. Yes. So now tell me, what are the addition of the charges? Against whom you want to add?
We want to add charges against accused 4 and 5 under
Okay.
302, read with
Yes.
120B and 34, Your Honor.
120B and 34. Why 120B and 34 together?
Your Honor, because there was both because there was both common intention and conspiracy, Your Honor.
So 120B will not
So
suffice.
even if 34 is not there, Your Honor, that will not make much difference. 302 and 120B should be there, Your Honor.
So I'm just subtracting 34.
Yes, Your Honor.
So you don't want 25 Arms Act, you just want 302 and 120B.
No, Your Honor, let 25 Arms Act be there. But apart from 25 Arms Act, 302 and 120B should be added.
Okay. So the PP, you just help me out one thing. I don't have the order of the charge framing order. I don't have.
I'm searching for it, ma'am. Actually, I cannot share screen with the help of. Yeah. Yes, ma'am.
Can
Please
you
tell.
tell me what was the reason given by the then judge that accused number 4 and 5 only section 25 Arms Act was implicated? Why not 302 and 120B? Can you
Your
tell
Honor,
me?
because the Honorable Sessions Judge said that there are no ample evidence at this stage to show the same.
So now,
However,
are you having ample evidence?
Your Honor, in the prosecution evidence stage, the fingerprint expert, prosecution
Yes.
witness 13, under oath has stated in his testimony that there were
Yes.
fingerprints of accused 4 and 5 on the gun from which the
Acha.
murder was committed.
Acha. So that was
Also, Your Honor.
exhibited? That was
Yes, Your
exhibited?
Honor. Yes, Your Honor.
Fingerprints report, right?
Fingerprint experts report. Yes, Your Honor.
Experts report were exhibited. Can you
Yes,
tell
Your
me?
Honor.
Can you tell me the exhibit number?
Ma'am, we have not still received because after that the lockdown happened. So the original file we don't have. So don't know the exhibit number. But if they can.
So are you sure that it has been exhibited? Because
Yes,
in
ma'am.
my order,
If they can.
if I add the charge,
No,
how
yes,
can
yes,
I
ma'am.
do it?
If you can share screen the prosecution evidence order, they have just projected it. In that, if you can show the fingerprint experts report, prosecution witness 13, the order of 166. Organizing committee, can I have that? The same document which you have shared.
Please tell the page number.
Prosecution
Your voice
13
is
page
breaking.
numbers in this.
Prosecution
witness 13, 13.
It has just 10.
Not this order. Order 66. My case. You have altered with the numbers in the. PE order for 166.
Give me a minute. Prosecution witness 13.
Yes.
Prosecution witness?
13, Your Honor.
Yes, but fingerprint experts report. I just want to know the exhibit, this thing, the number.
It's 181 and 187. Page number 181 and 187.
Can you please show, see, if you can take the trouble of showing this?
Yes, ma'am.
This is a very important thing, PP. You should have been equipped from beforehand when you're arguing on this particular fact.
Is this the one?
This is for the PW13.
Please unmute yourself.
PW 13/1 and 13/2, Your Honor.
Where is that?
Your Honor.
On page number 181. Statement of Ravi Kumar.
Ma'am,
Yes. Tell me.
Your Honor, at that time, the court was not having much time, so they have exhibited the whole document and then gave chance
I
for
understood. I understood the fact, but the thing is that if I want to give the order, so I cannot give
Yes,
the order on without any basis, right? So you are saying
Yes, Your Honor.
I agree with your statement that the fingerprints experts report were exhibited, but unless and
Yes, Your
until
Honor.
you tell me the number of that exhibit report, I cannot attach that, right?
Yes. So exhibit.
So
Just
if you want to take the time, you can do one thing. You can send that exhibit number in my WhatsApp to Pratiksha.
Your
Ma'am,
Honor,
it's
exhibit number is
PW13-1 and
PW 13
PW13-2.
13/2, Your Honor.
Tell
Yes,
me.
ma'am.
Exhibit number?
13/2. PW 13/2.
13/2. Acha.
Yes. And if you can.
This is the exhibit number 13/2. First time. Okay, tell me. Yeah. You're not audible. You're not audible. You're not audible. Pratiksha, can you hear me?
Yes, ma'am.
They're
Actually,
not
I think
audible.
Corner, you must be
he has
seeing.
a
So
network issue. I think he has a network issue.
Can I share my screen?
I will just talk to him. Just give me a minute.
hello.
Yes.
Yes, Your Honor. So the fingerprint experts report clearly proves the involvement of the accused in this case, Your Honor.
So where is the report? Where is the report? Can you show me?
Yes, Your Honor. Just a second.
Yes.
So this is the main finding of the report.
I cannot see.
Please
Do
tell
one
the
thing,
page.
Vaibhav. Do one thing. Can you hear
Yes,
me,
Your
Vaibhav?
Honor.
Yeah, do one thing. Please
Yes, Your Honor.
WhatsApp this, scan this document and WhatsApp in my number. To Pratiksha
Okay.
can WhatsApp. Because I need for this, for the, writing the order.
Okay, Your Honor.
Okay. Anything else?
You can tell the page number.
Page number 186. If you want, I can read out the result, Your Honor.
No, I just need it. I need to see it.
Okay,
Without seeing that, I cannot give you the any order.
Yes, page 186. It is findings and results.
See, Pratiksha, will you send me?
Yes, ma'am.
Okay. Anything else other than that, Vaibhav?
Your Honor, I think that is that will self-suffice this thing. That 302 should be added because even like if we go otherwise.
With 120B.
120B, yes, Your Honor.
Okay,
because the weapon was used for murder of Mr. 𝐒𝐔𝐁𝐄𝐑𝐈𝐁𝐄.
Okay. Anything else?
Is this the one? Findings and results?
Yes.
So which one you are saying? Findings
Your Honor,
and result पे कौन सा paragraph?
Paragraph 3.
That is 8791513. Conclusively matched with the fingerprint in exhibit 5. That is accused force fingerprint. Where is the 5? Accused number 5 का कहाँ है?
Next page, Your Honor.
This one.
Five. Okay.
8791501.
Okay, so this is the report. What is this exhibit number? This what I'm talking about. You are showing you have already reflected this, right? You have exhibited this. Tell me the
Yes,
number
Your
of
Honor.
that page. Exhibit number I want to.
Your Honor, that is, I think, prosecution witness 13/1.
13/1 or 13/2? You said.
13/2. 13/2. Sorry. Your Honor.
Page number. Page number.
Page 186.
186 and 187, right?
187. Yes, yes.
Take it. Take it. Okay. Exhibit 1. See, you're not understanding. I see there is na exhibit 5, exhibit 6, exhibit 4.
Yes.
So
Yes,
I
Your
just
Honor.
want that number of this particular finding and result. Did you get it?
Your Honor, but this is
If
okay,
you haven't
finding and result.
exhibited, if you haven't written the number in this manner, it was your fault.
No, but the Honorable Sessions Judge, while the prosecution evidence stage was going on, has allotted the same numbers, Your Honor. That is there in the prosecution evidence order as well.
Oh, it can be. Acha, theek hai. Okay.
They have done it like prosecution witness 13/1, फिर underline and then Sessions Judge.
But
So on.
exhibit number should be different. Okay, it's okay. Theek hai. Anything
Yes,
else?
No, Your Honor.
Your
I think that
Lordship.
will suffice my grounds.
Okay.
Your Ladyship, on
Yes.
the statement of Mr. Ravi Kumar, I will show you my screen. Let me allow OC.
Allowing. You can share now.
Counsel, you
Visible?
just tell me one thing. Mr. Shubham Kumar, just tell me one thing.
Yes,
You
ma'am.
are refuting the point of PP, right? So
Yes,
there
ma'am.
is a finding and result that has been shown in the exhibit number PW13/2 that there was fingerprints, right? So when there were fingerprints, how you're going to refute the finding and result of that particular document? Do you have anything else to say on that? I just want to hear that only.
Yes, ma'am. Actually, ma'am, in charge sheet there is mentioned that only the accused number 3 having the fingerprint on the gun, but in the statement you see the accused 3, 4, and 5. That means it is intentionally just involving the accused in this crime, and there is no involvement
No.
of such
That
accused.
is a matter of trial that will be corroborated by the evidence. That is a different thing. But
Ma'am,
some report is just tell me.
Indeed, your lordship.
Yeah, there is a report, right? The report is showing that there were fingerprints. I just want to ask you whether you have any documents to refute that presumption which was shown by our PP. Do you have any documents that that speaks otherwise?
Your lordship, in the charge sheet even it is mentioned that the on page 80 disclosure statement was attached. I will show you. Give me a minute, man. Ma'am, actually, the accused or on trigger, there is not specific mention by the ballistic expert or the Ravi Kumar, who is the examining the gun. He even not mention the fingerprint on a trigger who fired this. I know according to the charge sheet that accused 3, 4, and 5 having the fingerprint on a gun, but you can't involve all two in this matter. You can involve only one person who fired the gun, who have the fingerprint on the trigger.
So
And the report clearly.
what is the what is the ingredient of 120B of IPC or 34 of IPC?
Ma'am, 34, if more than two and more than two persons are committing the same crime.
If an overt act is performed by any of the persons who are involved with the crime, if any kind of overt act, can that person be booked under 34 or 120B?
Yes, Your Lordship.
You're saying yes.
He may be booked, but according to the reports, you cannot involve everyone.
What is the report? Report of the finger expert. The finger expert report is showing that there has been a fingerprint, right?
On the gun, not on the trigger, ma'am. What I
Yeah, on the gun. Might be that gun was actually transferred from accused number 4 and 5 to the main accused.
And Your Honor, moreover,
the trigger has been used only by one person. I mean, the accused person. So everybody has helped for the completion of the the full crime. All have participated. The common intention was there.
Indeed,
yes, Your Honor, and moreover, for the same purpose, 120A, the definition of criminal conspiracy, like falls into this, that it was if it is committed by two or more persons for a illegal act, and murdering a person is illegal act, Your Honor.
Yes, yes. Anything else? Anything else, Shubham?
Ma'am, there is doubt. One more doubt that.
So how can you say there is one more doubt?
Means the doubt was created in the charge sheet that only one gun bullets was fired, but the ballistic expert says it was more than 2 and 3 bullets. So it may be anyone can do this act, but the involving of accused is just like intentionally putting charges over them.
Okay. I'm reserving the order, and I'll just give the order and then I'll give to Pratiksha. Am I clear?
Okay, Your Honor.
Okay, ma'am. Ma'am.
Thank you so much.
Ma'am.
Thank you, Your Honor.
Excuse me, ma'am.
Yes.
Excuse me, ma'am. This is Nishan and the PP in the criminal application for 54, ma'am.
Yes.
Ma'am, I'm really, yes, ma'am. I'm really sorry, ma'am. I really apologize for the mistakes I made. Ma'am, I want to mention one thing, ma'am. Ma'am, in my case, if you allow me, ma'am, in my case, actually, the section 27 clause 3 is applicable.
In your case, 27?
Clause 3 is applicable, ma'am. Clause 3, no, section 5 is read with along with clause 1, ma'am. But in my case, clause 3 is applicable, ma'am.
So what does it speak?
Whoever uses any prohibited arms or prohibited ammunition or does any act in contravention of section 7, and such use or act result in the death of any other person shall be punishable with death.
Yes, what the other counsel is saying.
Vaibhav, are you there?
Your Honor, I'll just have a look at section 7 and then say.
Yes, please.
However, anyways, Your Honor, since there is no weapon in the case, the weapon has not been produced, so hardly that will matter.
Production, dekho.
That is a presumption, ma'am.
Not a matter of it has to be produced. If it is not produced, I mean, it is going to there is irregularity. You can say it will not vitiate the trial. It is only a mere irregularity. You can say it cannot vitiate the trial. But the thing is that it has been seized.
Exactly, Your Honor.
Am I right?
Your Honor, after seizure, even at the stage of prosecution evidence stage, when all the witnesses were brought, when all the evidences are brought, when the person who has seized the property, when
the prosecution, I just want to ask you one thing, when that witness was testifying in the witness box, so was that, that pistol was produced before the court and shown to them?
No, Your Honor.
Was this the gun from where, this bullet came out?
No, Your Honor.
PP?
Yes, ma'am.
Even Your Honor, the witness himself said that I have not seized it, and the signature was taken from me after 15 days of such seizure.
Ma'am,
Matlab,
this
I
is
don't understand.
Like when the witness was brought who has seized the
Yes.
pistol,
Yes.
we had
he was a part of
produced the
seizure.
I
seizure
mean the
memo.
IO. I
We
mean
were,
the IO.
He was a
yes,
part. No, ma'am, he was not the IO.
not the IO, ma'am. One sub inspector was there.
Okay, SI. Okay, okay,
One person who was part of the investigation team.
okay.
So when the seizure memo was shown to him and asked that whether this is your signature on the seizure memo, he
Yes.
right away denied that it is not my signature. Firstly, then he
Yes.
was asked that whether you were present at the time of seizure. He said no, I was not present. Then we
Okay.
had asked that how is your signature?
Vaibhav, from where are you referring all this is? Can you tell me the exhibit number or the statement?
Your Honor, statement of, just a second, statement of prosecution witness. Just a second, Your Honor. Statement of prosecution witness 5, Anand Kumar, Your Honor.
Yes. So, Vaibhav, can you tell me that, I mean, the murder has happened, right? Do you agree or not? That's a matter of trial.
Yes, Your
But
Honor.
when you are
Yes,
saying,
yes,
when you're
yes,
saying the
yes, Your
murder
Honor.
has
Yes.
happened, yes, the murder has happened, by which weapon, the particular person has murdered the other person?
Your Honor, they say that it had happened because of gun. However, even in the post-mortem report, Your Honor, the post-mortem report is prepared by the ballistic division.
Okay.
What?
So yes, sorry, the forensic report. Sorry, the forensic report is prepared by the ballistic division.
Yes, yes, I got it then.
Even the DNA reports and everything, even the blood sample report is prepared by the ballistic division. So we can
Okay.
hardly trust on the investigation. Also, Your Honor, the informant and the investigating officer is same person. So it has highly prejudiced this case's investigation.
Acha, theek hai.
Ma'am, in the High Court, we have already cleared that the informant was the IO, not the complainant. And ma'am, a complainant can be the IO of the case, and we really appreciate that. Yes, the informant can't be the IO, but the complainant can be the IO.
Yes. So,
Your Honor, but that was not proved, and however, a PCR report has been asked from the prosecutor within
Yes.
2 days. So once they produce the PCR report, then we can
So these
come to a
things are the part
conclusion
of
that
trial.
whether it
yes,
is not
yes.
part of trial. Like on the basis of the same, a bail was granted. So that is part of another case, Your Honor. We are currently talking about the alteration of charges under 216.
Yes.
Ma'am, can I say just 1 minute?
Yes,
Please,
yes, yes,
ma'am,
yes.
the only thing I want to say here is, ma'am, there is a death, there is a murder.
PP, how
The-
you going to defend yourself, PP? How are you going to defend yourself?
Yes, sir.
The person
Yes,
who
ma'am.
has actually the person. Just let me finish.
Okay.
The person who has actually seized the gun. You are saying this gun has been seized.
Yes, ma'am.
So somebody has seized the gun. Now the
Yes, ma'am.
person who has, you told that this person SI has seized. Now SI has deposed and testified that the signature does not match with his signature, and he's not the person who has seized the gun.
Ma'am,
And not even the SI, Your Honor. The eyewitness also has said that there were not one gun, there were 3 guns in the case.
Ma'am, can I continue now?
Yes, yes.
Ma'am, into the seizure memo, ma'am, that particular SI was among the 2 witnesses, ma'am. Else than that, there was one more witness who has testified that yes, the pistol was seized from the spot only. Ma'am, there is presumption. It is a matter of trial.
The seizure, actually the gun was seized from the spot.
Yes,
but by
ma'am.
whom? By whom?
By the IO of the case, ma'am. By the IO of the case, and he has testified. Yes, it was seized from
By
the spot.
IO or by SI?
By IO, ma'am. By IO. SI was just a witness for that.
Okay, so
Yes, ma'am.
IO has actually seized the.
Yes, ma'am. Yes, ma'am.
IO has
Seized the pistol.
seized the
The pistol.
gun.
Yes, ma'am.
And Anand Kumar, that is PW5,
Yes,
was
ma'am.
the
Anand Prakash.
witness.
Yes, ma'am.
Witness
Yes,
the
Your Honor.
fact that he has, but now in the witness box he has actually deposed a different fact that he haven't seen the person seizing the gun, right?
He has
Yes,
said,
Your
ma'am,
Honor.
that the signature doesn't match his signature.
No. He said that I have signed after
Fine.
10 to 15 days of seizure.
All right, all right.
After 10 to 15 days.
Of the seizure.
But IO said IO has actually signed it.
Yes, ma'am. Yes, ma'am. And he even testified that he sees it from the spot.
I got it.
Yes, ma'am.
Anything else?
No, ma'am. Very much
No,
obliged
Your Honor.
to provide me second chance, ma'am.
Thank you so much.
Thank you,
you,
Your
ma'am.
Honor. Thank you.
Yes, thank you so much. I'm reserving the order. I'll give the order once I'm done with it. Within tomorrow or day after tomorrow, I'll give you the order.
All right. All right.
Thank you.
Thank you so
Thank
much.
you, Your
Thank you so
Okay,
much.
ma'am. Thank you.
All right.
Everybody was very good. Keep it up.
Thank you.
All right, ma'am.
Thank you.
Obliged, ma'am. Much obliged, ma'am.
Thank you, ma'am. Thank you.
I'm ready. Thank you.
So do we leave?
Yes, you can leave.
Lakshmi. Ritika, Prati, Rohit, you guys can leave.
Please leave the meeting.
Lakshmi, आपको सो गए जग रहे?
ये ऑन करके चले गए.
हाँ बोलो.
डांट हो रहे हो? हेलो.
हाँ बोलो.
हो गई ये वाली मीटिंग भी.
चलो फिर कर दो बंद.
कुछ आपको कहना है क्या अभी?
नहीं बस बंद कर दो.